How to prepare to write your due process complaint. This content is for educational purposes only and does not constitute legal or medical advice. Are you tired of battling the school system? Frustrated that your child isn't getting the support they need? You're not alone. This content is for you. Many parents feel the same way. I'm Michelle Kotler. For more than 30 years, I've been an attorney, special educator, and now I'm the creator of the Parents Playbook for special education success. Today, we'll discuss how to prepare to file a request for a due process hearing under the IDEA. This process can feel confusing and overwhelming, but with the right guidance, you can navigate it effectively. First, let's clarify what the IDEA is. The IDEA, or Individuals with Disabilities Education Act, is a federal law that ensures children with disabilities receive an appropriate education in the United States of America. The IDEA applies to every public school in every state and federal territory for children from birth to age 21 or until they graduate. If you believe your child's rights under IDEA are violated, you can request a due process hearing and ask for a third party to decide what the school needs to do. Now, let's outline the general steps involved to prepare yourself. Just like laying a strong foundation is the most important part of building a sturdy house, the correct groundwork is essential. Begin by gathering your documentation. You'll need a copy of your child's entire educational record. Keep in mind that in most cases, you can only litigate over what happened in the past 2 years. However, being able to see the entire school history is critical to developing your theory of the case. For example, I've seen a situation in which an egregious IDEA violation occurred 10 years earlier, namely a wildly inaccurate eligibility decision that ignored the student's severe autism. This devastating error set the child on the wrong trajectory for his entire school career, forcing him to waste years in general education classrooms where all he did was draw pictures and watch YouTube videos. In a case like this, if you had only asked for the school records for the past 2 years, your whole theory of the case would be wrong. Get the full educational record, no matter how old your child is. Print or copy any other documentation that you have, such as emails with the school, written notes to and from the staff, and your child's work samples. You can use these documents as part of your evidence. Current work samples are particularly useful to show the judge what your child can and cannot do. Terrible handwriting? Show it. Can't do math to save his life? Show it. Reading is impossible? Show it. Like the saying goes, a picture's worth 1,000 words. Paint the picture in the judge's mind of how much your child struggles in school, and you're halfway home. If the judge is truly neutral and has a heart, that is. Next, in most cases, you will need to obtain at least one private evaluation to document your child's true and current functioning. The evaluator should also be able and willing to serve as an expert witness. You'll need to ensure your evaluator has the appropriate credentials for this purpose. Usually this would be some type of psychological, neuropsychological, or psychoeducational evaluation, although the type of evaluation you'd get depends on the case. The private evaluator will want to review your child's school records that you obtained. Your child may need more than one type of independent evaluation depending on the circumstances. Any independent testing you obtain must be provided to the school. They need an opportunity to review the data at a meeting which you will attend. The The school may accept or reject the findings of the independent evaluations. Do not attempt to sneak a private evaluation into the record at hearing that the school has never seen. This will backfire on you big time. Understanding evaluation reports, including statistical data and IEP writing, is crucial for identifying issues in your child's school records. Examine the total record carefully to find information that supports your case, as well as school records that could damage your case. For example, let's say your argument is that your child needs a more restrictive environment to have a smaller class size and more individualized attention from the teacher. The placement you want also uses a highly specialized instructional method to teach reading that the current school does not. However, your child has excellent report card grades in their current placement. Those report cards are going to damage the theory of your case. You can be sure your child's teacher will testify about your child's progress in a glowing manner. The school's attorney will argue that your child is doing fine where he is and does not need to be moved to a more restrictive environment, which is a violation of the least restrictive environment mandate anyway. She will add for good measure, "How dare we ever move a child out of general education? Heaven forbid!" You will need legitimate factual and legal reasons to get around those arguments, and sometimes those reasons exist. You need to know how to uncover those reasons and how to present them to the judge. Let's say you have an independent educational evaluation done by a well-credentialed expert, and you learn that your child is actually reading 6 years below grade level. Once you recover from your shock and fury at being lulled into a false sense of complacency, you need to swing into action and use the data to your child's advantage. Your expert could testify at the hearing that the school is socially promoting your child by subjectively inflating the report card. But the truth is, there is no way your child could be earning those grades independently. Also, the expert could testify that the more restrictive environment is needed to help close the gap in reading skills. The expert would testify about all the differences between the current and desired placements. The expert will testify that the desired placement's instructional method offers substantial benefits, unlike the current placement, as shown by your child's 6-year delay. For good measure, the expert might say that your child is running out of time to close the skills gap, which, sadly, is painfully accurate. In this way, you could overcome what we call bad facts. You might win at the hearing, even though your child has straight A's on his report cards. You can see through this example that each case is highly fact-specific, and that you may need to develop some of the facts yourself to support your theory of the case. Next, you should do legal research. Familiarize yourself with the relevant statutes, regulations, court cases, and agency interpretations that support your arguments. Take notes of the relevant citations and quote the legal provisions that were violated so you can weave them into your due process request. Each legal argument you make must be supported by the facts you can prove at hearing through documents and witness testimony. After you have examined all the records, obtained and shared independent evaluations with the school, and done your legal research, it's time to prepare your written request, also called a complaint. To have the best shot at winning, your complaint must be clear and logical about the facts, the legal provisions that have been violated, and the remedies you seek. Getting your complaint right the first time is vital, because amending it later can be difficult. To amend the complaint, you will need to get consent from opposing counsel or from the hearing officer, which may not be granted. If you want to delve deeper, including a guide on how to write your complaint and every other aspect of the due process hearing step by step, enroll in the Parents Playbook for Special Education Success. This 10-week online masterclass guides you through each part of the hearing process from start to finish, empowering you to advocate for your child like a professional without breaking the bank on legal fees. Transform frustration and overwhelm into confidence. Click the link below to learn more and start advocating for your child's rights today. Please like, subscribe, and share this video. Comment below with your special education questions so I can create future content to answer them. Thanks for watching, and see you next time.